Justice Reyes.
Clarificatory questions. I want to be, good afternoon, Mr. Counsel.
Good afternoon, Justice.
I want to be clarified on certain section, specifically section 17 of the RH bill, which provides, among others, which encourages health care service providers to provide at least 48 hours annually of reproductive health service to indigent and low-income patient free of charge. Do you agree with me, Mr. Counsel?
I think that is what the statute says, Your Honor.
Yes, that is the provisions of the statute, among others. However, in the last sentence of that specific section, the pro bono 48-hour annual reproductive health service is made a prerequisite
Yes, Your Honor.
for accreditations under the PhilHealth. Is it not?
Yes, Your Honor. That is what the statute
that is
says.
provided under the law. How would you reconcile the two statements that health care service providers are merely encouraged to provide pro bono reproductive health service, but make it a requirement for accreditation under the PhilHealth?
Yes, Your Honor.
That is my dilemma.
The government's answer, Your Honor, is that private and non-government reproductive health care service providers are not compelled to provide free RH care service and information. They're not compelled. Therefore, they absolutely have the right not to provide the information. But they are encouraged by the statute, and one of the ways by which they can be encouraged is by giving them this privilege of PhilHealth accreditation. And this accreditation is a very benign system because the range of RH care services that they can provide is very wide, and that will include those services that a conscientious objector would be willing to provide. Then I think that is a good compromise.
Is that a compelling factor as against the first provisions of the law, which only encourages the health
yes,
care
sir.
providers?
Absolutely, Your Honor. This is not a compulsory system, but there's a government institution called the PhilHealth which can accredit. Now, what the government is saying is, if you want accreditation, right, you will have to provide 48 hours of annual pro bono services. You don't have the right to that accreditation because it's a government privilege. And so, if you absolutely don't want to provide free or pro bono RH care services, then don't do it. Then don't do it. But if you want to provide it, we'll give you a bonus. And that bonus is accreditation under the PhilHealth. And any medical practitioner, right, would be well advised to do just that because anyway, the range of RH care services available under the statute is very broad enough to cover the practice of even the religious who will conscientiously object to the RH law.
Let's proceed to another section.
Yes, Your Honor.
More particularly section 7 of the RH bill, which provides inter alia require private health facilities to provide family planning services available to paying clients except in the case of non-maternity specialty hospitals and hospitals owned and operated by a religious group. Am I correct?
Yes, Your Honor. That is what the statute says.
The foregoing exception given to hospitals owned and operated by religious groups from providing family planning services is grounded on respect for religious belief.
That is true, Your Honor.
So that is the main purpose of objective of the law. What about in case of hospitals which, although not owned and operated by a religious group, is owned and operated by a person who belongs to a religion that objects to artificial methods of family planning? Are they also covered by that exception, Mr. Counsel?
You're referring, Your Honor, to
section,
Okay, to hospitals that are not owned by a religious group, but owned by a religious person.
yes, religious person.
Okay, I think, Your Honor, there's a distinction. If it's a religious group, I think the statute makes an assumption, right, that they might have some conscientious objector status. I would label this particular proviso of the law as an institutional conscientious objector status, and therefore they are simply required to refer. But in the case of a person who simply happens to be religious but owns a private hospital,
The private hospital. Would that
the
be
general
applicable?
proviso, the first proviso of the statute, will actually apply to the hospital owned by that person. Meaning what? That hospital, which is a private health facility, will have to provide RH care to paying clients. Paying clients, Your Honor. And so I think it's reasonable for the statute to make a distinction between a religious group operating a hospital and a religious person operating a private
who owns
hospital. Because I think a religious group operating a hospital would be an institutional religious organization. And so it's different from a person who simply happens to be religious but has enough money to establish or build a hospital.
Question, Mr. Counsel. Section 14 of the same law mandates the state to provide reproductive health education to adolescents, or those, in my view, are those from 10, 11 to 19.
10 to 19, Your Honor.
10 to 19 years old. So that is the law itself.
Yes, Your Honor.
In so doing, is the state not preempting the parents engaging in determining or gauging the emotional maturity of their children? That is, whether they are emotionally and mentally prepared for reproductive health education.
Okay. I think, Your Honor, because the state has an interest in the reproductive health and reproductive health education of future citizens of the Republic, the state is not precluded from making what it considers a judgment on whether or not age and development appropriate reproductive health education should be given to future citizens of the Republic. It is a complementary function to the primary role of parents, because parents will have their children almost all the time. They have their incentive mechanisms to ensure that their children would follow their moral or spiritual or non-spiritual beliefs. The state will have a partnership with these children only for a few hours every day, right? But the parents, they have a strong control over their children, and it doesn't necessarily have to be incompatible, Your Honor.
Thank you, Mr. Counsel.